Assalamualaikum.
Yeah, we are fine, doctor. Thank you so much.
Okay. All right, good. Okay, so shall we? So we are still under the topic of agency. Okay, so we are going to finish the remaining subtopic. So today we are going to focus on the duties of a principal to his agent. Okay, like what I said in my previous lecture, duties of a principal towards his agent uh, are not as many as duties of agent towards his principal, okay, because it involves only section 175 to section 178 only. So it's very simple. Okay, so if you are a principal, so what are your responsibility? What are your duties towards your agent? So under section 175, the first one is to indemnify agent against consequences of lawful acts, meaning that you have to pay, okay, to pay back whatever the agent has incurred expenses, to pay the agent the commission and other remuneration agreed. Okay, is either commission that you have agreed in the contract with your agent. Okay, how much is the percent? If the commission and other remuneration agreed or other payment agreed, unless the agency relationship is gratuitous. Gratuitous means free of charge. Okay, so unless if our relationship, our agency relationship is free, so I don't have to pay you. Okay, like for instance, my relationship with Jian Yu, our class rep. Okay, so he's doing the job on my behalf, but we do not agree on any commission or remuneration. So the relationship is actually gratuitous. Okay, percuma. All right, so that one, the first, that's the first duty of a principal to his agent, to indemnify, meaning that to pay the agent the commission that you have promised the agent to pay. Okay, unless if the agency relationship is free of charge. All right, and then the second duty is to indemnify agent, okay, to pay agent against consequences of acts done in good faith. So under section 176. So if the agent has proven that he has done something for the sake of the principal, he has done something in good faith, in bona fide. Okay, like in the case of emergency, the agent had uh, made a reasonable effort, okay, to save the principal's property, to keep profit for the principal. So the principal cannot prevent or, okay, cannot prevent or not to willfully prevent, hinder the agent from earning his commission. So the principal cannot find a reason not to pay an agent if it has been proven that the agent had actually acted in good faith to save his property or to keep the profit or to protect the principal's interest. That is under section 176. All right. So duties number one and number two is actually to pay the agent. Okay. So the difference is if the agent had done lawful act, meaning that the agent had complied with the principal's instruction, and if the agent had done something in good faith. All right, and the third one is not liable for criminal act done by an agent. So different with duties number one and two. Duty number three is as far as the criminal act is concerned or the criminal perspective is concerned. So the principal will not be liable to any act done by his agent. For instance, if the principal had assigned the agent to do certain work, all right, so in doing the work the agent had involved in criminal, let's say for instance the agent had uh, caused had hurt, okay, another party, or the agent had killed another party, for instance the agent had robbed another party, or any criminal offences. Okay, so the principal will not be liable under section 177. So even though there was a contract between the principal and agent, but if the agent had involved in criminal act, okay, so the principal will not be liable, and the agent will be liable personally, okay, without involving any responsibility from the principal. All right. And last but not least, under section 178, to compensate agent for injury caused by the principal's neglect. Okay, so if you are a principal, if you are an employer, for instance, in a company, okay, so if let's say because of your careless, because of your mistake, because of your negligence, your employee suffered injury, for instance, okay, during COVID-19, because you fail to observe a strict SOP, okay, or you fail to protect the safety of your employees, and as a result the employees suffered injury, the employees have to go through swab test and all that. quarantine, so you have to be liable to compensate agent for injury caused by the principal's neglect because of your negligence under section 178. All right, so these are all the duties of a principal towards his agent. Okay, all right. Are you okay so far? Any question before we proceed to the authority of an agent? Are you okay, guys? Can I hear some voices?
Yeah.
Okay,
Yes, doctor.
doctor.
All right, good. Okay, so authority of agent. So under this subtopic, we are going to discuss the agent's authority. Okay, the agent's right, what the agent can do and what the agent cannot do. The parameters or restriction, is any restriction, okay, for the agent's authority or to do certain act. So general rule or the general principle here, an agent's act are binding, meaning that whatever the whatever act, whatever action done by agent, whatever conduct, okay, done by the agent will bind the principal. The principal will be liable if they are done within the agent's authority, provided if the agent has done something which is within his authority given by the principal. If the agent had done something which has exceeded his authority or which is beyond his authority given by the principal will not be liable. So the general rule is very simple. If you are a principal, you will be responsible for the act done by your agent as long as the agent has not exceeded his authority, right? But if the agent has exceeded, if the agent has acted beyond his authority, you as a principal will not be liable. All right, but if an agent does an act which exceeds that authority, so given, the principal is not bound unless he adopts and ratifies the authorized act. Okay, remember we have already studied agency by ratification. Okay, at the beginning, originally the agent has no authority, but if the agent did the act and the principal ratified, meaning that the principal accepted, the principal agreed, the principal confirmed that act, okay, mengesahkan, so the principal will be liable. Okay, so these are all the general principle and exceptions as far as authorities of agent is concerned. All right, again, the types of authority, okay, that the principal give to the agent. So we have actual authority and also apparent or ostensible authority. Actual authority in bahasa, we call it kuasa sebenar or the real authority. Real authority or actual authority is expressly given by the principal orally or in writing. Okay, like for instance, in my case with Jian Yu. Jian Yu is, you have actual authority because I give the authority in orally, verbally. I said, Jian Yu, you will be the class rep for this semester, okay, for commercial law class. So in this case, the actual authority is given orally or implied from the express authority given. Implied is something that not expressly stated, not expressly demonstrated, but it can be implied. It can be concluded from the express authority or from the circumstances of the case, okay, based on circumstances of the case, custom or usage of trade and the conduct of the parties. Okay, even though if I did not say that I appointed Jian Yu as my class rep, but let's say based on my conduct, okay, I always ask you to report to Jian Yu or to deal with Jian Yu if you want to make an appointment with me. So impliedly, Jian Yu has an implied authority. Okay, so like in my case with University Malaya, I have express authority because my authority given by University Malaya is in writing. I have a letter of appointment, okay, which stated that I have been appointed as a lecturer for this faculty. All right. And the second type is apparent or ostensible authority, is that which is not expressly given by the principal, but which the law regards. The law considers the authority is not given, or even though it was given, it has been terminated. Okay, but the law regards the agent as possessing, although the principal has not consented to his exercising such authority. Okay, for instance, I am a lecturer. Okay, as a lecturer, of course, the nature of duty, the nature of my job is actually to deliver lecture. By the name of the lecturer, by the position of the lecturer, I have an authority to, the law regards or the third party will assume that, the student will assume that, of course, by the name of the lecturer, by the position of the lecturer, I have an authority to deliver the lecture. I have an authority to set up final exam questions. All right. But let's say, for instance, I have committed misconduct or any criminal offences, and the Universiti Malaya has already terminated my service. Okay, but the third party does not know. The students do not know that I have been terminated. So when I conduct my lecture, you have attended. And when I conduct final exam, okay, you join the final exam. So in this case, to what extent the principal will be liable, and how about the right of the third party? Okay, so the answer is secret or private restrictions on the authority of the agent do not affect the third party who does not know of such restrictions. Meaning that if the students have no knowledge about my termination, have no knowledge about my misconduct that I have been taken a disciplinary action against me, the Universiti Malaya has taken disciplinary action against me. Okay, I have been is either terminated or dismissed. Okay, but if the student do not know, you still have a right to attend my lecture, and if you have set for the final exam, you still have a right to claim your mark, okay, your exam mark, because you know nothing about it, about the restriction. Okay, and who has acted in good faith in relying on the agent's apparent authority, meaning that you are relying on my ostensible authority, you are relying on my apparent authority, you are relying on my status as a lecturer, you do not know about the private restriction that Universiti Malaya had already taken against me, okay, and you are acting in good faith, so you have a right to claim. Okay, similar with the let's say let's take the more real and practical example. For instance, you are the bank manager. Of course, by the name or the position of the manager, you have not the bank manager, the company manager. Okay, so you have a right to, let's say, for instance, make a loan or borrow the money from the bank. Okay, for your company. All right. So, but let's say the company has already terminated you, and when you are dealing with the bank officer does not know about the reality that you had been terminated. Okay. So the bank officer released the loan. So in this case, the bank officer will be protected if he does not know the restrictions that the company has taken against you, and he has acted in good faith. So the bank can still claim the repayment from the principal. All right. Okay. All right. So we come to the last part of the topic of agency here, that is termination of agency. So how agency can be terminated. You sign a contract of agency. Okay, principal and agent sign a contract, and later they want to terminate. How they are going to terminate. All right. So there are two ways of how agency relationship can be terminated. The first one is by act of the parties. The second one is by operation of law. Okay, by act of the parties. Okay, that is parties here referred to by act of principal and agent. Okay, so it can be by mutual consent. Both parties agreed. Okay, mutually consented that, for instance, I said to Jian Yu, I appointed you as a class rep, but we agreed that after the semester ended, okay, after completed the whole semester, so you will be discharged, you will be terminated. That is by mutual consent. Okay, or by revocation by the principal. Revocation by the principal meaning that you are not satisfied with your agent service. So you can terminate, you can revoke, and you can hire another agent. All right. Or by repudiation of the agency contract by the agent. So it's another way around. This is an agent who was not satisfied or who is not able to perform, and the agent can repudiate, meaning that he can terminate the agency relationship by giving the notice to the principal. All right, so this is by act of the parties. How about by operation of law? When I said by operation of law, meaning that if that things happen by hook or by crook, okay, the agency relationship will be automatically terminated. All right. So the first one, there are 5 ways of how agency can be terminated by operation of law. The first one is when the contract of agency has been performed under section 1554, meaning that you have already performed, you have already, done your part. So you are discharged. That means your agency can be terminated. Okay. So you have performed your job. That's it. Or upon the expiry of the period fixed in the contract of agency. Okay, the contract of agency had, upon the expiry of the period fixed in the contract of agency, supposedly, for instance, you're supposed to start your work on 1st May. On the 2nd May, 1st May is the Labor Day, right? On the 2nd May or on the 1st April, okay? But unfortunately, you cannot start by 1st April. So in this case, the contract has been expired and the principal can terminate it. Can terminate the agent. All right. Or upon the death of the principal or agent, okay, today you sign a contract of agency, tomorrow one of the parties died, either the principal or the agent, so the contract will be automatically terminated. All right. Or when the principal or agent becomes insolvent or is made bankrupt or by frustration, okay, when an event happens which renders the agency unlawful. Okay, today you sign a contract of agency, tomorrow or 2 days later, principal or agent becomes insolvent. Insolvent meaning that not able to pay your debt or is made bankrupt. Bankrupt and insolvent is actually two different events. Insolvent before you have been declared as bankrupt. All right. So, or by frustration. Frustration is under the topic of discharge. I have already shared with you my voiceover slide. Okay. So, frustration is one of the ground where the contract can be terminated. For instance, you sign a contract, but suddenly something happened. The contract cannot be continued, not because of the fault of the both parties, both contracting parties. For instance, a certain event happened. Okay, COVID-19, you cannot continue, you cannot proceed to order the goods, you cannot deliver the goods. So that's considered as frustration. Okay, so agency relationship can be terminated by frustration. All right, and last but not least, when the principal or agent becomes insane, unsound mind. Today you sign a contract, tomorrow one of you becomes insane. So the contract of agency can be terminated. All right, so that's all for the topic of agency. Any questions? Any question, guys?
No, doctor.
Okay, since we have okay, I think we should proceed with the new topic today, that is a contract of sale of goods, even though sale of goods has been scheduled to week 10, but since we still got time, so I will start a little bit about the introduction. Okay. So we are done with the agency. So bear it in your mind, agency is one of the topics for the final exam. Okay. All right. Okay, so under this topic, we are going to discuss law of sale of goods. Okay, or in bahasa we call it contract jualan barangan. So under this topic, we are going to deal with the definition of what is meant by goods, what is meant by sale, okay, the types of sale, the like sale by sample, sale by description, selling of the goods by not the owner, okay, all the legal issues pertaining to sale of goods. Okay, and this is also one of the most important topics in our life because it's practical, because every day we involved with a sale of goods. Every day people selling and buying goods. Okay, so when you study the law of sale of goods, at least you know your rights as a seller and you also know your right as a buyer, or and together with your responsibilities provided by the statutes or act. Can you see my slide now?
Yeah, doctor, we can see.
Okay. All right. So for your information, before we proceed, yeah, when we discuss contract, that is Contract Act 1950. When we discuss agency relationship and contract of agency, we also refer to the Contract Act 1950. But when we discuss sale of goods, contract of sale of goods or law of sale of goods, so the primary statute or the act here is the Sale of Goods Act 1957. Okay, so bear it in your mind. The year here the year here is very important because it differentiates between Malaysian Contract Act and other countries' Malaysian Sale of Goods Act and other countries' Sale of Goods Act. Okay, so 1957 belong to Malaysia. Because we also have Sale of Goods Act, English Sale of Goods Act 1979, we have Indian Sale of Goods Act, we have Singapore Sale of Goods Act, okay, we have Australian Sale of Goods Act, but the year here is different. All right, so the Sale of Goods Act, the statute here applies to contract for the sale of all types of goods, including second-hand goods. So if you are buying something or the good which is second-hand, not first-hand, you are also governing by the same Sale of Goods Act 1957, and there is no distinction between commercial sales, private sale, or between wholesale and retail. So in Malaysia, all sale of goods transactions will be governed by the same Sale of Goods Act, regardless of the type of the sale, whether commercial or private or between wholesale and retail. All right, next. Definition. What is meant by a contract of sale, or in Bahasa we call it contract jualan. Okay, what is the meaning of meaning of a contract of sale? According to Section 4, Sale of Goods Act, it is a contract whereby the seller transfer the property in goods. So the property, the goods, there is a property in goods, meaning that the right. Okay, the seller has transferred his right over the goods to the buyer for a price. So in order for the buyer to get the good, the buyer has to pay the price. All right, so the seller had transferred the right, the ownership, okay, to the buyer for a price. Okay, how about the definition of goods? What is meant by goods, or in Bahasa we call it barang. Okay, barangan. Under Section 2, goods are defined as every kind of movable property. So this is actually very important definition because it differentiates goods with other things. Goods in the sale of goods contract, goods under the sale of goods contract means movable, something that you can remove, something that you can be carried along, movable. Okay, fixtures are excluded. So fixtures like something which is fixed, okay, it will not govern under the sale of goods. All right. Okay, so goods can be household items, can be vegetables, can be meals, etc. Category of goods. So we have existing goods, we have uncertain goods, we have specific goods, and we have future goods. All right, so existing goods meaning that goods already owned or possessed by the seller, meaning that when you are buying the goods are already there, the goods are already in existence. Okay, for instance, you go to the shop and you want to buy the goods which has been displayed. So the goods is actually existing goods. Uncertain goods, goods identified by description only. Okay, uncertain meaning that the goods are not there, but you describe, okay, you request, you as a buyer describe to the seller, I want to buy a laptop, for instance, or a printer, laser printer, or you give specification to the seller. All right, so uncertain meaning that the seller cannot confirm which type of goods, the seller cannot ascertain which type of goods that you want to buy. Description also can be both, from the buyer or from the seller. Or when the buyer asks the seller's advice, so the seller will describe the goods. Okay, this goods will be blah blah blah. So this description. Specific goods, goods identified or agreed upon at the time a contract of sale is made. Okay, you are buying a car, so you had seen the car, you had examined all the specification, and the goods are already in existence, so that we call it specific goods. Okay. Future goods, goods to be manufactured or produced or acquired by the seller after the making of the contract of sale. When you buy the goods were not there, okay, but you have to order the goods, that what we call it future good. The seller will be manufactured. The seller will manufacture the goods. All right. Okay, let's do some exercise here. Okay, we have three situations here. The first one is A, bring a bracelet to a goldsmith and ask him to make her a necklace. Okay, is that a sale of goods between A and the goldsmith? You have to refer to the definition of the sale of goods just now. Okay, the definition must be transfer of property by the seller to the buyer for the price. How about the first situation? Is it the sale of goods? A bring a bracelet is actually the the gold bracelet, for instance, okay, to a goldsmith. So a bracelet belong to A, right? Is there any transfer of property?
No,
Yeah,
just for
there is.
service. Yeah.
Yeah, there is no transfer of property, so definitely it is not the sale of goods. It's more towards contract of service because A, the owner of the goods, asks goldsmiths to do something, right? So it's contract of service. There is no transfer of property. It is not the sale of goods. How about the second situation? A goes to a goldsmith and choose a gemstone and asks him to make earrings. Is there any transfer of property here? The
Yeah.
gemstone, yeah,
Yeah.
the gemstone belong to goldsmith, right? And A will buy the earring. All right, so it's actually sale of goods because there is a transfer of property. Right, and how about the third situation? X goes to market, bring with him 10 kilogram of sugar cane and changes it with 3 kilo rice. So definitely this is not a sale of goods because it is exchange, yeah? So X changed the 10 kilogram of sugar cane with 3 kilo rice. So that's more on what we call it, more to butter trade. Okay. All right. Okay, so definition of ownership and possession. Okay, for your information, when you are dealing with the contract of sale of goods, there are certain terms which are common. I mean, common terms. Okay, normally we always use these terms, ownership and possession. So what is meant by ownership and what is meant by possession? Or in Bahasa, we call it, I forgot the terms of ownership means, forgot the what's is the term?
Is it a milik?
Keempunyaan, sorry.
Okay.
Hak, yes,
Milik.
ownership, hak milik. Yeah, hak milik and possession, keempunyaan or what? I forgot the legal, I mean, Malay words for ownership and possession. Okay. Yeah, ownership definitely hak milik, right? Okay, possession is the goods is kept under your possession, under your disposal, but you are not the owner of the goods. But ownership, you are the owner of the goods because you have the ownership. You have a right to do whatever you like to the good. You can sell, you can transfer, you can dispose of, right? But possession, you are not the owner, but the goods had been kept under your possession. For instance, you borrow the goods from your friend. The car had been kept in your, I mean, in your house. So in this case, you have the possession, but you are not the owner. All right. Okay, so we are going to discuss in detail. Ownership, meaning that if you have the ownership, can be said to be the absolute interest in the goods, meaning that you own the goods absolutely. Okay, you can enjoy the absolute interest in the goods, meaning that the fullest right that are possible to have in goods, including the right to possess, to enjoy, to use up, to alter, to destroy, or to alienate. So in this case, if you are the owner of the goods, you can do whatever you like to the goods. You have the ownership. You have a right. Okay, no one can challenge your ownership. All right. So if anyone would like to have a good, would like to possess the good, I mean, he or she has to buy from you or to get your approval, consent. Okay, possession. It may refer to manual detention or actual custody. Okay, actual custody meaning that the goods is under your custody, but that doesn't mean that you are the owner. Okay, maybe you borrowed from your friend, or maybe your friend asks you put the goods under your disposal. Okay, under trust. Your friend trusted you to keep the goods. Okay, so if it refers to a legal possession, it can be said as an intention to possess altogether with the control of the goods. So under legal, as far as legal perspective is concerned, despite apart from ownership, possession, they are actually another category that is legal possession. Legal possession meaning that the owner give it to you together with the right to control the goods. Okay, so a person who is in possession of the goods can be said as the owner of the goods. Okay, on the surface you are the owner of the goods, but when you're talking about the ownership, you have no ownership if you have only possess the goods, right? Okay, apart from the terms ownership and possession, we have also another common terms used when you are dealing with sale of goods transaction, that is condition and warranty. Remember, when you are buying the goods, okay, people always talking about warranty. How many years is the warranty for this product? Okay, so what does it mean? What is the legal implication of a condition and warranty? All right, so under Section 12, Subsection 1, Sale of Goods Act, the conditions had been defined under Section 12, Subsection 2, a term which is essential to contract, meaning that a term, okay, terma, which is essential to contract, which is very important to the contract. Breach of it would allow the other party to repudiate the contract. Okay, if any of the parties breach the conditions, so another party, the innocent party, can repudiate or can terminate the contract. Okay, whereas warranty under Section 12, Subsection 3, a less vital term of a contract, less vital meaning that not important, less important term of the contract, breach of it would give rise to a claim for damages only, but not a right to discharge or to reject the goods. That's why when you are buying the goods and the goods were defect, okay? So in this case, you have a right to claim a warranty, but not to reject the goods, not to return the goods and get back your money. But normally the owner or the seller will repair the goods, okay, and give back to you. So in this case, under Section 12, Section 4, whether a particular situation is a condition or a warranty depends in each case on the construction of the contract. Okay, sometimes a condition may be called a warranty. So it depends how you construct the contract agreement. The agreement under Section 12, Section 4, whether a particular, how to determine whether the term is a condition or a warranty. It depends on the agreement between the buyer and the seller. But unfortunately, in most cases, for instance, if you are buying electrical goods or any goods from the seller, from the owner, so normally the seller has already prepared their contractual agreement, the contractual terms. So you just agree. So you cannot request. Okay, so because you are the one who need the goods from the seller, so you have to agree. The seller is actually the dominant party, so you have to agree with what the seller has already fixed. Okay, for instance, the warranty for the goods is 1 year, or currently most of them are practicing extended warranty. So they extend the warranty and they ask you to pay more, so that anything happen to your goods within 3 years, for instance, you still can claim for damages. All right, so the advantage of extended warranty for the seller, because the seller can get more payment from the buyer, but the advantage of extended warranty for the buyer can still repair the goods for free, okay, if the goods were defect within 3 years, otherwise only 1 year warranty. So it depends how the party want to categorize the terms, whether condition or warranty. And sometimes a condition may be called a warranty. Okay, condition, for instance, one of the conditions, if you want to sell the goods, you must be the true owner or the actual owner of the goods. If you have stolen the goods from any person, so you cannot sell the goods because you don't have the ownership. That is a condition. So breach of condition, another party can repudiate or cancel the contract. Let's say you said that you are the owner of the goods, you have a right to sell. Okay, Jan Yu, for instance, you want to sell your handphone to me, and you said that yes, I have an ownership because I am the real owner. So I agreed to buy, I paid the money, but later I found that you are actually not the real owner. You have stolen the handphone from your friend. So in this case, I am the innocent party, so you have breached the condition that in order to sell the good, you have to be the owner. You had breached that condition, so the innocent party can repudiate the contract, meaning that I can return the handphone and get back my money. Okay, so that's the difference between conditions and warranty. So now you know the difference, basically the difference between condition and warranty, and also ownership and possession. All right. Okay. Okay, now we are going to discuss the next detail, implied terms. Implied terms meaning that even though it is not stated, expressly stated in the agreement, but it can be concluded, okay, that the terms must be applied in the sale of goods contract. The Sale of Goods Act implies a number of stipulations in every contract for the sale of goods. Okay, Sale of Goods Act had prepared or had provided a number of stipulations in every contract, only applicable if the parties not if the parties do not exclude or modify the terms. So in your contract, if there is no formal contract written, okay, so automatically you can use Sale of Goods Act provisions relating to stipulations of the terms, okay, provided if you have not exclude or modified or you did not change the terms of the contract provided by the Sale of Goods Act. So we are going to discuss what are those implied terms provided by Sale of Goods Act 1957. Okay, so when you are buying the goods, remember we are dealing with the contract of sale of goods only. Implied terms, there are 1, 2, 3, 4, 5, 6 implied terms. The first one is implied terms as to time. Okay, under section 11. So according to the sale of goods contract, section 11, time of payment are not of the essence of the contract. Not of the essence meaning that not important. Okay, time of payment is not important under section 11. But when parties agreed that time of payment is of the essence of the contract, meaning that it's important, essential, if buyer fails to pay on agreed date, the seller can repudiate the contract. Okay, so even though in the section 11, it stated that time of payment is not of the essence, meaning that if the other party breached the time of payment, so what the parties can do is only to claim for damages, okay, not to cancel the contract. But if the parties highlighted or expressly stated in the contract that time of payment is very important, is of the essence of the contract, so if the buyer fail to pay on the agreed date, the seller can repudiate the contract. A simple example, for instance, the contract of sale of goods between me and Jian Yu just now. Okay. Let's call other names Jian Yu, and we have here Lee Ka Wei. Lee Ka Wei, are you there?
Yes, doctor.
Okay, let's say contract between me and Ka Wei. Okay, I agreed to buy Lee Ka Wei's handphone. All right, and we agreed that, sorry. Where were we? Right. Okay.
Slide 13, I think.
Slide 13. Yeah. Okay. All right. Thank you. So, because how to get rid from this? Slide 13. Yeah. All right. Okay. Let's say Ka Wei is the owner of the handphone, and I want to buy his handphone. Okay, and we agreed that Ka Wei said time of payment is very important to me in our contract. So if you want to buy my handphone, you have to pay today at 9 a.m. Okay, so at 9 a.m. You have to pay, and we agreed that time of payment is of the essence, meaning that it's essential to the contract. Okay, so if I fail to pay on, at 9, I paid at, for instance, 9:30. Okay, if buyer fails to pay on the agreed date, the seller can repudiate the contract. So Ka Wei has a right to cancel the contract. Okay, where the other terms as to time is of the essence of the contract depend on the party's intention as provided in the contract. So it depends on our agreement, how we are going to construct. Okay, time of payment, if we follow section 11, it is not of the essence, meaning that if the buyer fail to pay on time, the buyer cannot repudiate the contract. The buyer can only claim ganti rugi or damages only. But if let's say we come up with our own contractual terms, we have modified, okay, whatever that had been provided by the Sale of Goods Act, it can be done. So in this case, if I paid late to Ka Wei can cancel the contract. So it depends on the parties' agreement. That is implied term as to time. But if there is no agreement between us as regard to time of payment, so automatically section 11 will be applied. If the buyer fail to pay on time, the seller cannot terminate the contract. Right. So second is implied terms as to title. Title means ownership or hak milik. Okay, title here meaning that your name must be there, must be stated as an owner. Okay, so under section 14, subsection under section 14A, implied condition. Okay, about the title, Section 14, Subsection 14A Sale of Goods Act had provided that there is an implied condition on the seller. Condition. Remember, we have discussed the legal implication, the breach of condition. What happened? The innocent party can cancel the contract. Okay, has a right to sell the goods. Implied condition that the seller has a right to sell the goods. For instance, A sells piano to B, B paid the purchase price, B discovered that the piano is actually belong to C. So A has breached the condition of the contract. So in this case, B can repudiate the contract and get back the price in full. So under Section 14A, there is an implied condition that the seller has a right to sell the goods. We have a case here, Roland against Deval. So the buyer bought the car, and unfortunately, after 4 months, after he has paid for the car, so this fella, okay, the third party came and claimed that actually I am the true owner, I'm the actual owner of the car. Okay, the seller had stolen from me and sold it to you. Okay, so in this case, the court held that the seller or the defendant had breached the condition of the contract, which is implied term as to title. So the sale can be cancelled. All right. Okay. All right. So this is implied term as to time. Okay, not of the essential of the contract is not a condition, but implied term as to title is a condition to the contract. Okay, the innocent party can cancel the contract. Implied warranty as to quiet possession. What is meant by quiet possession? Quiet possession, if we translate it from bahasa, it means pemilikan aman. Okay, meaning that you can own the goods without any distraction from the third party. Okay, so you can enjoy the goods as you like. When you buy the goods, you can enjoy the goods, meaning that quiet possession. So it is implied warranty. So it's not implied condition. So section 14 subsection B categorize quiet possession, the right of the buyer to enjoy quiet possession, as an implied warranty, not a condition. Remember the legal implication of breach of warranty. So under section 14 subsection section 14B, okay, buyer shall have and enjoy quiet possession of the goods, no interference. Yeah, meaning of quiet possession, meaning that no interference from the seller or the third party. So in this case, once you bought the goods, you have a right to enjoy the goods. Okay. In the case of a breach of the warranty, the buyer can claim damages only, but not to cancel the contract. Let's say you bought the goods today, but tomorrow, you cannot enjoy the what we call it quiet possession. There is interference from the seller himself or from the third party. So what you can do is actually under section 14B is to claim damages only. Boleh menuntut ganti rugi sahaja, but not to extend to cancel the contract. However, it depends on the third party. If you want to classify or to categorize quiet possession as a condition, you can do it. You can expressly state it in your contract. Okay. So we have a case here. A sold his car to B. Even though he has sold the car, he has always persuaded B to lend him the car. Okay. So even though A had sold the car, A had transferred his ownership over the car to B, but he always asked to borrow the car from B. Since he has a car key, he used the car whenever he liked, regardless whether B needs the car or not. So this is actually B was not enjoying quiet possession because A always disturbed. Okay, so A has breached the implied warranty that B should have and enjoy quiet possession. So but what B can do here, what B is right here, can cancel the contract or can claim for damages. Guys, are you here with me?
Claim for damages.
Yeah, correct. Claim for damages only. Why? Because it's only breach of warranty, not breach of condition. Okay, next, implied warranty that the goods are free from encumbrance. What is meant by free from encumbrance? Meaning that free from any charge or mortgage or from the third party's right under section 14 subsection C. So this is again implied warranty, meaning that if the warranty had been breached by the seller, so the buyer can only claim for damages, but not to the extent to terminate or cancel the contract under section 14C. Goods shall be free from any charge or encumbrance in favour of any third party not declared okay, not informed by the seller during the sale or known to the buyer before or at the time when the contract is made. Okay, we have the case Yes Stinky against Edward. The plaintiff who had bought the car paid off the tax owing and sought to recover it from the seller. Okay, the plaintiff here bought the car, but unfortunately there was a tax that the plaintiff have to settle. Okay, and sought to recover, meaning that after paying the tax, the outstanding of the tax, so the plaintiff claim from the seller, defendant seller. The court allowed the claim, the plaintiff's claim, for there was a breach of implied warranty, because when the time the defendant seller sold the car, he failed to clear all the tax that he has to pay, right? So the plaintiff should pay, I mean, must have to pay the tax. All right. So the plaintiff can claim from the seller because the seller breached. There was a breach of warranty. All right. So next, implied condition. Okay, this one is different. Condition as to fitness for particular purpose under section 16. We are going to discuss further under the sale by description here. Section 15 and section 15. Implied condition that the goods must correspond with the description. So we are going to discuss under a separate subtopic, that is sale by description, section 15. Okay, you are buying something by description. What does it mean? Meaning that it's either you did not say the goods when you are buying the goods, but you describe. Okay, for instance, you requested from the seller, can I have a simple example? Can I have toothpaste for braces? Those who are wearing braces, you have a special toothbrush, not toothpaste, toothbrush. So in this case, you have described. So in this case, the seller, when the seller want to provide the goods to you, supply the goods, the seller must fulfill the condition that you have already stated. That is, you want a toothbrush for braces. Okay, so in this case, the seller must fulfill the buyer's description. That is toothbrush, not the normal toothbrush, but the toothbrush for braces. Okay, so there is an implied condition on the seller that the seller must fulfill this condition. If the seller fail to provide the goods as described by the buyer, so under section 15, the buyer can cancel the contract. Why can cancel? Because it is a breach of condition, not breach of warranty. Okay, so contract by description can be when you are buying something online. Okay, you read the description. For instance, cordless iron. Okay, and then the power, blah blah blah. You read all the description, but when the seller delivered the goods to you, you found that the condition that had been described by the seller on the website, okay, not complied or not fulfilled. The goods, I mean, the goods is different. The good that you receive, the good that had been delivered by the seller is different. So in this case, you can cancel the contract, meaning that you can return the goods and claim for your money back. So implied condition under section 15, and also implied condition as to fitness for particular purpose. You have already stated the purpose. Why did you buy the goods? For instance, you want to have a whatever. For instance, pharmacist, in the pharmacist case, for instance, you want to buy the medicine, okay, for pregnancy, for instance, or for you are allergic for certain types of medicine. So in this case, the pharmacist must fulfill your purpose. Okay, so implied condition as to fitness for particular purpose. Or a very simple example, you order pizza, for instance, Domino's pizza, okay, and you have already described you want the, what we call it, cheese burst or whatever, okay, whatever types of pizza, okay, and when you said that you want for particular purpose, so the seller must fulfill your purpose under section 16. Failure by the seller to provide the goods which is fit for your purpose, the buyer also can claim, can cancel the contract. So these are all the terms that had been provided by sale of goods, which can be applied, which can be used by the contracting parties, okay, if there is no special or if there is no another agreement provided by them. So impliedly, automatically, this term can be applied, provided both parties have not excluded or modified any terms. Okay. All right. sale by description under section 15. Okay, I think I stop here. So any question before we proceed with presentation? Presentation today is by group 4. Am I right? Group 4, are you ready? Today is your turn. Yep. Okay, so I think, okay, before that, any question relating to sale of goods? So you should know your right, because every, like nowadays, currently, you are buying online. So make sure the good that you receive from the seller fulfill your description. If the seller fail to fulfill your description, you have actually you have a right to fight. Okay, I mean to return the goods and get back your money.
Sorry, Doctor.
Yes.
For the cases relating to the Sales of Goods Act, do we, I mean, can we refer to the Contract Act 1950? So in making the solution for this, for the cases relating to Sales of Goods Acts.
You have to refer to Contract Sale of Goods Act. Yeah, Sale of Goods Act 1957.
So we don't need to use the law in the section in the Contract Act 1915.
No.
Oh.
Yeah, unless if the issues like undue influence, fraud, if the issues, I mean, if there are issues, okay, involved, contractual issues involved, basic contractual issues involved, then you can apply also Contract Act 1950. But if the facts of the case, if the issues are totally on sale of goods, then you have to use Sale of Goods Act only. Okay. So bear it in your mind, Sale of Goods Act 1957 is specifically for sale of goods transaction, whereas Contract Act is actually basic and can be applied to all types of contract, including sale of goods contract. Okay.
Okay.
All right. Okay, guys, any question?
Doctor,
Yeah.
regarding the part for possession on slide 8.
Slide 8, part 4, yes.
Possession, the last sentence says that a person who is in possession of the goods can be said as the owner of the goods. Does it, just now, do you say that if the person is in control of the good, means he's the owner? Is it like that?
Yeah. Meaning that to certain extent under legal possession, sometimes the owner, the real owner of the goods give the party, okay, together with the right to enjoy the goods. I mean to control the goods. Okay, for instance, they give you have rented out the building, for instance, all right, but at the same time the owner also give you a right to sub rent. Okay, so you can actually enjoy the rental paid by the tenant, okay, even though you are not the real owner of the goods, but it can be said that you are the owner in this perspective, in this how to say, in this context. Okay, meaning that you are not the true owner, but at the same time the owner actually approved and consented that you can sub rent the one of the rooms, for instance, and you can also collect the rental. So on the surface you are also the owner in that context only. Okay.
All right. Thank you, doctor.
All right. Okay.
Doctor, I have a question actually.
Sure.
On implied terms, I'm not very clear about the difference between implied condition that goods must correspond with description and then implied condition as to fitness for a particular purpose. Could you please?
Okay. Sure. Implied condition as to goods that must correspond, meaning that the seller must fulfill or must comply the buyer's description. If the buyer said that I want this goods, okay, the printer, for instance, laser printer, okay, the buyer described one of the description is the printer is laser and the printer is a color printer. The printer can be printed out double-sided. Okay, so all these three description, if you are the seller, you have to fulfill all these three description. If let's say you fail to fulfill any one of the description, let's say you deliver the printer, but the printer has no color, it's black and white. So you fail to fulfill the description. And this is actually implied condition that you have to fulfill. So in this case, the buyer can cancel the contract, meaning that can return the printer and get back the money, or can ask for the another printer which is fulfill the description. All right, that is for description. Is it clear?
Yes, doctor. What about for fitness?
Particular fitness for purpose. Let's say, for instance, you are actually allergic for certain types of medicine. Okay, for instance, you are pregnant or you allergic for certain types of any meds. Okay, and you have already told the seller or pharmacist or any types of goods. For instance, you want to buy a cloth or material, and you have already told the seller that I want the material, okay, the cloth, which is full cotton, okay, 100% cotton. I don't want polyester or artificial cotton because my skin is allergic. Okay, I can wear cotton only. Okay, you have already mentioned your fitness for purpose, particular purpose, meaning that you have a special requirement, and the seller must fulfill. If the seller failed to fulfill, meaning that the seller gave it to you the cloth which is not suitable for you, okay, for your skin. Okay, so in this case, the seller had breached the condition to provide the goods for which fit for your purpose. So the seller can, the seller had breached the contract, and the buyer can sue the seller, can cancel, meaning that can return the cloth and get back the money. All right, that is meaning that you have stated your purpose. Why did you buy the goods? Is it clear?
Yes, doctor. Thank you.
All right. Okay, we are going to discuss in detail. Don't worry, yeah, under sale by description. Okay. So if you have already mentioned your purpose, why did you buy the goods but the seller failed to fulfill, okay, your purpose that fit for your purpose? So in this case, the seller will be liable. All right. So any question before we proceed? Okay, I think group 4, you can prepare your presentation now. If there is no questions. Okay, group 4. Don't forget, your submission for your assignments, for your group assignment will be in week 10. All right.
Jinhui decided to immigrate to Ireland after planning for 6 months with her family. She decided to sell her house located at SS2 Kuala Lumpur with the pricing of 4 million ringgit. So she posted this offer on Instagram to seek for interested buyers. After 3 days, Jinhui received a message from Instagram. A person called Cynthia was interested to buy her house, and Cynthia also accepted the pricing.
Wow, this house very good eh. I want to buy this house.
Hi, Ian.
Hi Jinhui, I saw your post on Instagram and I'm interested to buy your house for 1 million ringgit. We are best friends. You sure you accept my offer, right?
1 million? The price of house is 4 million and you want 3 million discount? No, the price is not reasonable. I won't accept your offer.
Hi Jinhui, we already knew each other for 10 years. We are best friends. How come you don't want to give a discount to me?
3 million discount is not a reasonable discount, and actually I already found an interest buyer who willing to pay me at 4 million.
Jinhui, you should give a priority to me because we are best friends. How can you treat me this way?
Oh my god.
After Ian hung up the phone, she scolded Jinhui very well because she really hopes to own Jinhui's house. So she started thinking on how to get the house.
must buy her house. Her house is extremely big and beautiful. I shall collaborate on to let Jinghui sign the contract.
Later.
Hi Jinghui, I am very sorry for my bad attitudes yesterday. Can you forgive me? I will not talk like this anymore.
Yes, of course. We're best friends.
Jinghui, I ordered the most popular drinks in this cafe for you. Come on, you must try this.
Oh, thank you. I must try it.
Oh no!
Why did I feel so dizzy?
Haha, you drink something special. Delicious or not? Come on, sign this contract. You should sign this contract. You should sign this contract. You should sign this contract.
3 hours later.
Huh? When did I sign the contract? Why the price become 1 million only? Oh my god. Something fishy must be going on with my drinking. No way. How can Yen treat me like this? I'm not gonna to forgive her. Hi, Dr. Teo.
According to the checkup report, some value of indicator are abnormal, but it shows that your body have overdose tranquilizer which could harm your body, like you will feel dizzy and unconscious. So you should rest well, and I will give the medicine so that you can recover soon. And later I will give you the report to prove your body condition.
For me, Yen, I'm not going to let this go. I will let you pay back on that. I shall sue you in the court.
Court is now in sessions. We will now hear the opening statement from the defendants to defer the plaintiff to rest their case.
Good morning, Your Honor. Ladies and gentlemen, I'm Ng Yu-dong. I'll be here as the lawyer for the defendant, Ms. E.M. Based on this case, the contract was signed with a consent and there is no evidence to prove my client put the drug into the drain. Thank you, Your Honor.
Thank you, counsel. You may now hear the opening statement from the plaintiff. Do you have any evidence to prove that the plaintiff is unsound mind while signing the contract?
Thank you, Your Honor. Ladies and gentlemen, I am the plaintiff lawyer Li Shuwei. The following evidence proves that my client, Ms. Jinghui, signed the document is in the unsound mind. Let's look at the doctor letters, which reveal that there are tranquilizer components in your plaintiff body.
Although the report shows that the plaintiff's body has overdosed tranquilizer, but it couldn't imply that my client is the one who conducted it.
Your Honor, let me show another evidence to prove that my plaintiff is in unsound mind. It's the conversation between first defendant and second defendant, as well as the time they put the medication, is clearly recorded by the CCTV. According to the Section 12, Subsection 1 in Contract Act 1950, it says that a person is said to be of sound mind for the purpose of making a contract if, at that time when he makes it, he is capable of understanding it and forming a rational judgment as to its effect upon its interest. In this situation, my plaintiff cannot think rationally and do not know what the contract is about. In addition, the plaintiff has been provided the proof from doctor stated that she is under mental disorder. The defendant took advantages for this condition. As the result, the contract is void. Based on the evidence above, I humbly request Your Honor to publish defendant. Thank you.
Defendant counsels, do you want to give some justification of their actions?
No, Your Honor.
All right. Thank you, plaintiff and defendants, for the submissions presented just now. The verdict has been made by the court. Considering the circumstances and evidence addressed, I hereby held that the plaintiff sued successfully.
As a conclusion, the court held that Jinhui Su, Yi Yan and Ong successfully as referred to Section 11 and Section 12, Subsection 1 of Contract Act 1950. According to General Rule of Burden of Proof, contract entered by an unsound mind is voidable at his option, while the fact of mental disorder can be proven and the other party knows of his or her condition. By referring to the case Imperial Ron Limited Company against Stone at 1892, first section of Queen's Bench Report, page 599, since Jinhui has been proved her unsound mind status, so the contract is invalid. And thank you for watching for our video.
Okay, thank you, Group 4. Any questions? Okay, I'm sharing with you the QR code for today's attendance. All right, here you go. You can capture from your spectrum, yeah? Any question, guys? Any question relating to your assignment? So don't forget, yeah, your assignment you have to submit on 11 May, week 10, and also the group that has presented your presentation, you have to share in Teams. Please make sure you share all the videos in Teams, yeah? So we have the remaining group 5, 6, and 7. All right. Okay, guys, any question? Everything okay?
Yes, doctor.
Okay. All right, good. So I think that's all for today. So I will see you next class. So please take care of yourself. Stay safe. Stay at home. Okay, the number is increasing, yeah, for COVID-19 cases. All right. So okay. Assalamualaikum. Thank you. Bye.
Thank you, doctor.
Okay.
Thank you, doctor.
All right.
Thank you, doctor.
Bye.
Thank you, doctor.
Thank you, doctor.